The 1938 USDA Yearbook of Agriculture was titled Soils and Men. Writing in the preface, Secretary of Agriculture Wallace said, "The social lesson of soil waste is that no man has the right to destroy soil, even if he does own it in fee simple. The soil requires a duty of man, which we have been slow to recognize." Secretary of Agriculture Wallace was correct in noting that as a nation we've been slow to recognize the duty to the soil. But beginning over 65 years ago, Iowa has built a strong legal foundation for doing so. In the late 1930s, Iowa enacted our version of the Model Soil Conservation Statute. This is the act that creates the soil and water conservation districts that exist in every county in the state. The law gives those commissioners the power to develop and implement soil and water conservation programs, including the authority to establish mandatory soil loss limits. In what's perhaps the most powerful section of that statute, section 161A.43, titled Duty of Property Owners, which was added in the early 1970s, the law provides that to conserve the fertility, general usefulness, and value of the soil and soil resources of this state, and to prevent the injurious effects of soil erosion, it's hereby made the duty of the owners of real property in this state to establish and maintain soil and water conservation practices as required by the regulations of the commissioners of the respective soil and water conservation districts. In 1943, the Iowa Supreme Court faced a constitutional challenge to the law that the General Assembly had passed in 1939, which gave tenants the right to advance notice of termination of farm leases. In talking about the legislation, the court said, "Certainly such legislation was designed to correct the evils of an ever-increasing farm tenancy situation to the end that the public welfare and prosperity would be promoted." And the court said, "Clearly, it is within the power of the legislature to designate farm tenancy as a subject of police regulation." In another portion of the ruling that is as powerful today as when the court wrote it over 65 years ago, the Iowa Supreme Court said, "It's quite apparent that during recent years, the old concept of duties and responsibilities of the owners and operators of farmland has undergone a change. Such persons, by controlling the food source of the nation, bear a certain responsibility to the general public. They possess a vital part of the national wealth, and legislation designed to stop waste and exploitation in the interest of the general public is within the sphere of the state's police power." The court went on to say, "The legislature evidently felt that unstable tenure leads to soil exploitation and waste. The amendment aims at the security of tenure, and it's therefore within the police power of the state." In 1979, the Iowa Supreme Court faced a constitutional challenge to the state's soil loss limits. The case arose in Woodbury County, and it involved a dispute between neighboring farmers. The Soil and Water Conservation District Commissioners had resolved the dispute by ordering that one farmer needed to either take a field out of production or establish terraces on his farm. The farmer challenged the commissioner's decision and said it was unconstitutional to expect him to expend money on his farm to protect soil conservation. The case was decided by the local district court, which in fact ruled the law unconstitutional. But in a unanimous decision, the Iowa Supreme Court upheld the law and said it was clearly constitutional. And in fact, the court said the state has a vital interest in protecting its soil as the greatest of its natural resources, and it has a right to do so. And in fact, the court recognized that the law would require the farmer to make an expenditure on his land, but the court said this is a power that the state has the right to exact. The Iowa Supreme Court's 1943 decision in Benshooter and the 1979 decision in Woodbury County were both decided in this chamber, the historic Supreme Court chambers in the state capitol. Those two decisions established the strong basis in Iowa law for the duty of landowners to protect their soil and their land.